All right, good morning, everyone.
Good morning, Judge.
Many lawyers here, especially the ones who want to be pleased. We definitely have to find some alternative dates. Did anybody go with the jury questionnaires?
Yeah, I'll call it, yeah. That's what we are.
Laura, and Olivia,
That's where I'm at. Hey, that's one, sir. Second trial. Should be able to get around that. Yeah.
all right, where is everybody?
It's
It's Monday.
Okay, Wanda Dawson here, Wanda Dawson. That's Amara Kramer. Tracy Gray.
All right, council, I'm ready to go. I'm starting the trial at 10 o'clock. Uh, Mr. Raceback, you ready?
Yes, ma'am.
All right, this is the matter of State of Ohio versus Marquise McCollum, case number B2507226. Mr. McCollum is present in the courtroom, his attorney is Tom Raceback, Mrs. Brandon Brown, president of the State of Ohio. This matter is on today for a trial setting, and it's my understanding that, we need to execute a jury.
Sure, yes, ma'am.
I don't know.
Do you have one? Ready?
I do not have one.
Thank you.
Just I'm having signed it off for now.
Whatever you want to do, just make sure that the attorney might offer to talk to your phone. The other dates.
Judge, we have set this, I believe, it's set for bench trial, I think it's on June 3rd, is that correct?
Yes. All right, I need to go over those forms with them, so you'll need to explain it to them before we do that.
Okay.
We'll do it by the trial conference, is how it- Next one first.
Mayor Bergeron?
Yes. Thank you. All right, so Mr. McCollum, I have in my hand a single page document that is entitled waiver of trial by jury. At the bottom, there are signatures. I recognize Mr. Raceback's signature here. Is that your signature right above where it says defendant?
Yes, ma'am.
All right, so this is an acknowledgement that you understand that you have a constitutional right to have a jury trial. But when you sign this form, you're indicating to the court, I know my right to have a jury trial, I don't want to have a jury trial. I want to have a bench trial, where just the judge decides. Is that your understanding of what we're doing this morning?
Yes, ma'am.
Do you have any questions about this form?
No,
Do you have any questions about your constitutional right to have a jury trial?
no.
So I'm gonna go ahead and execute this as well today, April 13th, 2026. And I'm gonna file, we already have our trial date set, which is on, June 3rd at 10 o'clock, that's a Wednesday. I will protect that date. We will set this matter for a final pre-trial conference, what date is that? Thursday, May 21st. Thursday, May 21st. Is that correct?
That's a good date, yes.
All right. Thursday, May 21st, at 9:30. Mr. McCollum, please keep in contact with your attorney, and you will be here on that day, okay?
Yes, ma'am.
All right, anything from the state?
Not on the stage, Judge.
All right, now, Mr. Raceback, sometimes I do final pre-trial conference via Zoom, but we'll let you know plenty of notice and keep this time. And if you do that, your client can appear via Zoom, but he has the ability to song. Okay? All right, time waiting.
Yes, ma'am.
All right, thank you very much.
Thank you,
Anything else you want to discuss?
I'm sorry.
Anything else you want to
Nothing.
discuss? All right, thank you.
Thank you.
Thank you. All right, who's next? I'll be moving quickly, I'm gonna start the trial at 10.
Judge, you call my item, please.
All right,
Good night.
good morning. This is the matter of State of Ohio versus Mariana Dukes, case number B 2506410. Ms. Dukes is present in courtroom with her attorney, Mr. Doug Nicholas, and Mr. Brandon Brown of the State of Ohio. This matter is on for a pre-trial today. Council, we have a jury trial date set June 1st, and a final pre-trial conference date set May 21st. Do you have discovery?
Yes, Your Honor.
All right. Anything you want to come on, Mr. Brown, regarding discovery?
Nothing on the stage, Judge.
All right, excellent. Well, I'll make a note that discovery is complete. And, do you want to continue this matter as already said for the final pre-trial conference, or do you want somebody to?
So on Thursdays, I'm up in Hamilton. I met with Ms. Dukes. We would like to engage in some plea negotiations. If we could maybe do, I don't know if the court's available, May 12th,
For what?
for a clear trial setting, but I would hope that we'd be able to enter a plea that day.
Well, this is what I like to do.
Sure.
I like to do it. My dates are set. If you, after, having plea negotiations are successful in resolving it,
Mhm.
then let the court know and I'll set it for a plea.
Sounds good.
You know, I've done that before and it doesn't work out, and I face how it will be.
Sure.
So, and then I don't want, misuse for state's consent from that if necessary.
Understood.
So we'll just keep it on for May 21st at 9:30 unless the parties let the court know in advance and one other date.
Okay, thank you.
Anything else?
No,
Time waiting?
yes,
Ms. Hughes, stay in contact with your lawyer. Mr. Brown, anything else you want to put on record?
nothing on the stage.
All right, thank you very much.
Thanks, Judge.
Mr. Bobo, you ready?
Mr. Long's being brought down here.
All right, excellent. Ms. I will need to, reschedule that trial. Looks like. We would. Come along. Any day. Doing Anyone else ready? Yeah. The 30th? Oh, congratulations. All right, let's see. To all of you who are here on time, you're waiting, I apologize. I'm here on time, you're here on time, and the lawyers are here on time. But they have several rooms to be in. And I don't rely on come here first because they know I start on time. So, I don't know. Hello, how are you?
Second seat brand new meeting.
This photo, you know, work with Dave with this highlight so that when your client comes, we can, just see it done.
I don't think you have to find.
Okay, so. Right. I'm not trying to go there. Yeah. So, 519.
You know, for as long as probably this courthouse has been here, cases have been all set at the same time. I don't know why. We got here 6 years ago and tried to stagger the times so that lawyers who need to be in this court or some other police court could still be here on time and their client would have to wait, officers didn't have to wait. But it didn't work. It didn't work. So if you have any suggestions on how this courthouse can run more efficiently, where the lawyers don't have to be in the same, have to be in 15 different rooms at the same time, I am all ears. There are 30 judges in the village, 16 common pleas, 14 municipal court judges. And we actually have one or two visiting judges, so we have like 30, 31 judges in the village. And everything's at the same time. It doesn't make any sense to me. I just, we need to do a study, particularly from the public, because they take on the work, you know, they get to school, and officers, they gotta come down here and they gotta sit and wait. And it's really not the lawyer's fault, because they have to be in 16, 17, 18 other rooms at the same time. So, we gotta figure this out. We gotta figure it out.
We are starting a jury trial. We did Mr. Smith ASAP. And so, Judge, what's bailiff, if there was a law, he's a constitutional system. He was she is right here. You know, you also so he said, oh, yes, 16. So I said, well, yeah.
Mayor Kramer, Kramer?
You have the ability to send messages. To the system. Obviously, I have to because I can't see it. And my new suggestions, we can try to start early. And we're like, okay, come on, they still don't come the same at that time. They still don't. I was just and I saw the person that and she saw it's probably listening to judge's phone. But I've been there 3 times. I'm not going to. So I did talk about school. Yeah, absolutely. It's not actually. We've already done it, scheduled through June.
Let's see. Miss Hunter, can you have Miss Perkins, I mean, not Miss Perkins, Miss Bachelor, come on down, ready to start. Okay.
Was he in there?
Uh-huh.
He has 2 or 3 tries. And so you should stay there. And now it's fine.
Mr. Sawyer helping out?
Yes.
Okay. Mr. Fox, I'm ready to call your case. Do you need to calm down?
Your Honor, could I just have 1 second to speak,
Yeah.
Mr. Green?
Yes.
Lucretia Faulkner. Lucretia Faulkner.
You call William Harris, Judge?
This is the matter of State of Ohio versus William Edward Harris, case number B 2600757. Mr. Graham Fox is present on behalf of Mr. Harris, and Mr. Brown is present on behalf of the State of Ohio. This matter is set for pre-trial. Mr. Fox, we do have a jury trial date set May 19th, and final pre-trial conference date set May 7th, which is the Zoom. Do you want to comment on that?
No, thank you.
Okay, this presence way, do you have discovery?
We do.
Discovery is completed, Mr. Brown?
I think so. I don't have them marked on here, but I'm just gonna go back and check and make sure I sent everything.
All right. Do you believe that we have everything?
I believe so, yes.
Okay. All right, do you want us to keep this on for the final pre-trial conference?
Without being on Zoom, Your Honor, we would ask for a potential date in between time. We've made a plea offer to the state of Ohio, and the state of Ohio has subpoenaed the prosecuting witness in this case to be present. The prosecuting witness, to my understanding, is not here today. With that, we will still maintain our plea offer to the state. That's my understanding. Mr. Brown will speak to his supervisors about accepting that plea offer. And for the court's edification, Mr. Harris is on parole.
Okay. All right, so why don't we do this? Since there's plea negotiations, if the state accepts the defense's offer, I'll set it for a plea, and I'll answer for a plea. Work through schedules to dance for a plea. Otherwise, I'll just keep it on the final pre-trial conference and let them know. Okay?
Thank you.
All right, so just let the court know how we feel it is. All right, thank you.
Thanks.
All right, for those who are involved in the trial, if I can see you up here for just a moment.
So let me see if I may. Well, so the patent instruction is first actually, I think, just pursuing some position about potential to resolution. Last week, you know, I told her that we want to think over options that we have to cross over some cases and people that we want to testify. I'm kind of explaining to them, community what this is going to be, it's either testify or try to do it. You know, we're doing this for us, pretty currently, I can remember, that's kind of where I'm packing.
Also, I work with Kevin on
This is the matter of State of Ohio versus Christopher Long, case number B2202042. Mr. Long is present in court, along with his attorney, Mr. Kevin Lowe, and Mr. Chris Sawyer, president of the State of Ohio. This matter is on today for a pre-trial, and Mr. Bobo, we have, right now is a jury trial date set May 19th, a final pre-trial conference date set May 7th. It's my understanding that Mr. Long wants to waive his right to have a jury trial and execute this waiver.
He has, I wanted to put a sidebar, just about the scheduling part. We're hoping not to push our court date back. He's in custody on this matter. So worst case scenario, we're hoping to keep the same trial date, but we're not intending to have a jury trial.
Okay, well, I'll have to look to see if it's convenient for the court, only because, as you know, on Mondays, which just we set on a jury trial date Monday, I set several cases at one time.
Yes, sir.
And while Mr. Long does the priority because he is in custody, I do bench trials on Wednesdays.
Okay.
And so I think between now and that week, which is just next month, my Wednesdays are full with bench trials.
Okay.
So it may have to be, I don't know, Ms. Howard, what about that Wednesday? I'm sorry, what?
There's a lot of things listed, but there's no bench trial or bench jury.
Okay, what about that Monday, sir? It's on that Monday. I don't want to set Mr. Long's case, knowing that it's not going to go, and it's going to extend his time in custody.
So 19, it should be March.
Oh, yeah. Yeah, so that it's a lot of, sacrifice some time, it's actually scheduled to go that week, the day before. the 19th. How long do you expect this to be?
May I put this on?
Yes. So what can we do on 27? 27. 27. All right. So, Mr. Long, I have in my hand a single page document entitled waiver of trial by jury, at the bottom there are signatures. I recognize Mr. Lowell's signature here in his, House State Bar number. Is this your signature right, Bob?
That's correct.
All right. This is an acknowledgement by you that you understand you have a constitutional right to have a jury trial. But when you sign this form, you're indicating to the court, I understand my right, but I don't want to have a jury trial. I'm waiving my right to a jury trial. I don't like this trial to the court or to the judge. I would a bench trial. Is that your understanding of what you were doing when you signed this form?
Yes, sir.
You signed this form after consulting with Mr. Bobo about your constitutional right to have a jury trial? All right. I'm going to go ahead and execute this form and set your bench trial just a week later on Wednesday, May 27th at 10 a.m. Is time waiting until then, counsel?
It is done.
All right. All right, this case is pretty old. I do need to set a bond on it. Although this is receiving stolen property, I'm not sure if the state has had the opportunity to, comply with Marcy's law, but it's not a defense asking, there's just that he was AWOL for 4 years. There was a case he was issued, and so now that he's here, I just need to set a bond. And so I'm gonna set a bond. Is there anything you wanna say about that, Mr. Bobo?
He's being held in a misdemeanor management. Misdemeanor cases.
Okay, all right. I'm just gonna set the bond at 75,000 straight secure. We're gonna go ahead and take care of this matter on May 27th. Now, final pretrial conference is remain on May 7th. And then the bench trial will be on May 27th.
Yes, sir.
All right?
Yes, sir.
Anything else, Mr. Bobo, on behalf of Mr. Long?
No, thank you.
Mr. Sawyer?
Your Honor, what was the final control?
May 7th.
Thank you.
And the jury, bench trial will be May 27th. Bond will be set 75,000 straight and secure. Thank you very much, gentlemen.
Thank you.
Mr. Johnson. Unfortunately, I use a couple of cases on the docket. Well, not unfortunately, but we have two hundred.
Yes, sir.
All right. Mr. Story, take care of those.
Your one has been worked out complete at the Williams, but I will note for you. We'll give you the keys there. I do have to keep you.
Okay, all right, well, I'm just sitting here, so I'd like to be busy.
Let me look.
Yes. What about your other case, Mr. John, your clients not need to be brought in, work that, all your clients being brought in?
But I was listening, here, my client was running behind, I had that contact, with him. He should be here, he might actually been all down, I checked, but, I talked to him about 10 minutes ago, he said he's about to his house. I don't believe there's any crossroads in this. Let me check it all out. That's correct.
Well, I'm not sure it's the case that he's not here. I'm ready to call it. So this is Okay, well, I'm ready. This is the matter of, state of Ohio versus, if you want to talk and see how, what the CTA is, because, he has an opportunity right now, but I'm not gonna do that, he's not here.
Absolutely, Judge. Absolutely. Thank you. All right.
And Mr. Williams is gonna say that. Is this actually one of her cases, she was? It is. All right. Numbers off and stuff.
You said he's walking in the front door.
Mr. Williams, do you want, Mr. Brown, you want his,
Yes, sir.
And I stabilized for a victim impact as well.
thank you. And this is probation violation, you want to solve that.
We do.
Mr. Gustafson, I'm gonna have to reschedule you. Start the trial. All right, so, Mr. Matt, I'm gonna have to probably schedule Mr. Black, you can come talk to Mr. Howard, and do our start trial. And that's at 30. Mr. Gustafson, same thing. And, This is the matter of State of Ohio versus George Hopper, case number E 2506007. Mr. Hopper is present in the courtroom with his attorney, Mr. Neil Bachelor, and Mr. Chris Sawyer is present on behalf of the State of Ohio. This matter is set today for a plea. I have in hand plea documents. Ms. Bachelor, is this very kind to proceed?
Yes, Your Honor.
All right. Mr. Hopper, is that true? You want to resolve your case today by way of guilty plea?
Yes, ma'am.
All right. Are you the George Hopper named in this indictment?
Yes, ma'am.
Mr. Hopper, can you tell me how old you are?
I'm 22 years old.
How far did you go to school?
How far? All the way to my senior year.
Did you graduate?
Yes, ma'am.
All right. And so, you're able to read and write the English language well?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Have you ever served in the military?
No.
Mr. Hopper, I have in my hand a single-page document. It's entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Ms. Bachelor's signature here, but right above, is this your signature?
Yes, ma'am.
This is an acknowledgement by you that you understand that you have a constitutional right to have a trial. But when you sign this form, you're indicating to the court, I understand that, but I don't want to have a trial. I'm waiving or giving up my right to have a trial. Is that your understanding of what you were doing when you signed this form?
Yes, ma'am.
Did you sign this form after consulting with Ms. Bachelor about your constitutional right?
Yes, ma'am.
Do you have any questions about it?
No.
Any questions about your constitutional right to have a jury trial?
No, ma'am.
I also have in my hand a 3-page document,
Yes.
and it's entitled Entry Drawing Plea of Not Guilty, Entering a Plea of Guilty. Now, on the 3rd page of this document, there are signatures. I recognize Mr. Sawyer's signature here, Ms. Bachelor's signature there, but right up here, is that where you signed, sir?
Yes, ma'am.
All right, thank you. Mr. Prosecutor, please show the record the party's expectation regarding this plea.
Your Honor, today's expectation with the court's permission, the defendant will be entering a plea of guilty as charged, count 1, that's having weapons while under disability, with counts 2 and 3 being dismissed. The defense has also agreed to forfeit the firearms that were recovered. This is an open plea to the court. There is no agreed recommended sentence.
All right, thank you very much. Ms. Bachelor, is that accurate?
That is our understanding.
All right. Mr. Hopper, is that your understanding as well?
Yes, ma'am.
Mr. Hopper, are you under the influence of any medications, is it alcohol or drugs today?
No, ma'am.
Do you now have ever had to manage any type of mental health difficulties?
Well, in my opinion, it's sleep real bad, but I was on that since for it when I was younger.
Okay, are you still taking prescribed medication?
No,
All right. Did the doctor take you or you just stopped?
I just thought this was it. I was kind of laying myself off and it kind of got my attitude back where I need to be.
Okay. Well, ADHD has a lot to do with concentration and focus.
Yes,
Are you able to do that today? I may make you nervous.
Yeah, that's all it is. I'm just ready.
Okay. All right. Are you presently under any type of probation or community control supervision in this state or any other state?
No.
Has anyone forced, threatened, or coerced you in any manner into entering into this plea of guilty today?
No,
Has anyone promised you anything at all other than the dismissal of counts 2, 3, and 4, including count 1?
no,
Are you making this plea of your own free will?
yes, ma'am.
Now, the state has indicated, this is a 3-count indictment. But based on your lawyer's negotiations with the state is looking to dismiss counts 2 and 3 in exchange for your plea to charge to count 1, which is having weapons on disability and felony to 3rd degree. Is that what you talked with Ms. Bachelor about before this hearing
Yes,
today?
ma'am.
Did you have an opportunity to review this 3-page plea form with her before this hearing today?
Yes, ma'am.
Do you understand what it says?
Yes, ma'am.
Do you have any questions about it?
No,
Did Ms. Bachelor answer all of your questions about it?
yes, ma'am.
Mr. Hopper, do you believe you had enough time to sufficiently consult with Ms. Batchelor about your entire case before this hearing today?
Yes, ma'am.
And has Ms. Batchelor answered all of your questions to your satisfaction?
Yes, ma'am.
Have you had an opportunity to either review and or discuss the evidence the state has against you with Ms. Batchelor before today's hearing?
Yes, ma'am.
All right. Mr. Prosecutor, could you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, it came to your knowledge to the defense?
Your Honor, the state has provided all discovery, including any Brady material to the defense.
All right, Ms. Batchelor, you were not seriously.
Based on my review of the discovery, Judge, discovery was complete.
All right, thank you. Mr. Hopper, are you satisfied with your lawyer, Ms. Batchelor?
Yes, ma'am.
Now, do you understand this charge that is expected that you will enter a guilty plea to having weapons while under disability, a felony of third degree?
Yes, ma'am.
And do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegation of having a weapon while under disability?
Yes, ma'am.
And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, ma'am.
Now, this being a felony of the third degree, do you understand that you're facing up to 36 months in prison and up to a maximum fine of $10,000?
Yes, ma'am.
Do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years? Do you understand that?
Yes, ma'am.
And if I place you on if you're sent to prison, you get out of post-release control, and you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that?
Yes, ma'am.
Are you on post-release control right now?
No.
Well, Mr. Hopper, if you are on post-release control, so what I'm talking about right now is if I were to sentence you to a term of imprisonment, you were released from post-release control, but while in post-release control, you picked up a new felony offense and you were convicted. That's what I'm talking about, that scenario right now.
Okay.
If you are convicted of a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court can add an additional consecutive 1-year prison term, or whatever time remaining to the post-release control time, or whichever is greater. Do you understand that?
Yes, ma'am.
Any questions so far?
No.
Now, I told you the worst case scenario. Let me tell you about another. Since this is a felony of the third degree, community control or probation is a possibility. Do you understand that I can place you on community control or probation for up to 5 years instead of sending you to prison?
Yes, ma'am.
Do you understand that if you are placed on a community control sentence, you would have to comply with all conditions of community control?
Yes, ma'am.
Also, if I place you on community control and you violate the conditions of community control, then you're gonna be brought back before me for a more restricted sanction, which could include a whole host of penalties, but the most severe penalty could be the imposition of prison time, up to the 36 months that I previously discussed with you. You understand that?
Yes, ma'am.
Also, when I impose court costs and you don't pay those court costs, I could order you to do community service instead of paying court costs. You understand?
Yes, ma'am.
Now, Mr. Hopper, if I were to place you on community control, I would fully expect that you would be compliant.
Yes, ma'am.
But can I tell you a few ways that people are not compliant with community control?
Yes, ma'am.
The first is they are convicted of a new offense. They're arrested and they're convicted of a new offense. That's an immediate violation of community control.
Yes, ma'am.
The other biggest way is that they just don't comply with all the conditions of community control. So say there's 5 conditions and you do 4.5. That's still an immediate violation of community control. Do you understand?
Yes, ma'am.
And then the third biggest way that most people, it's not as obvious to people, and that is you leave the state without permission of probation or the court. Do you understand?
Yes, ma'am.
And the reason that comes into play is because we're so close to Northern Kentucky.
Yeah.
And it's also an Indiana border, right? And so you leave the state of Ohio without permission while you're on community control, which is a direct violation of community control. Do
Yes,
you
ma'am.
understand that?
Yes, ma'am.
All right. Any questions?
No, ma'am. All I'm about to say is I'm actually about to start a landscaping job, and it's in Scranton, Ohio. And we go from Kentucky to Indiana, so all types of different places because it's like where the jobs are located at.
I understand, I appreciate you telling me that in advance, I'll keep that in mind.
Yes,
All right, when you plead guilty, because some very important constitutional rights, I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons?
yes, ma'am.
You have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer. Do you understand that?
Yes, ma'am.
Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you?
Yes, ma'am.
Do you understand that at a trial, it's the obligation of the state of Ohio to prove your guilt beyond reasonable doubt?
Yes, ma'am.
And finally, do you understand that at a trial, you cannot be forced to testify against yourself?
Yes, ma'am.
Do you understand these rights I explained?
Yes, ma'am.
Do you have questions about your constitutional rights?
No, ma'am.
Do you have questions about anything we discussed here today?
No, ma'am.
Do you understand that if you plead guilty, count one, you are giving up or waiving all of these important constitutional rights in this case? Mr. Hopper, knowing everything the court has discussed with you today, do you still wish to enter guilty plea to count one as charged, having weapons of all disability at felony third degree?
Yes, ma'am.
All right, counsel, is there anything further before I accept the plea?
Nothing else from the bench, Judge.
Okay, may I hear say class?
On or about October 28, 2025, in Hamilton County, State of Ohio, the defendant George Hopper knowingly acquired, had, carried, or used a firearm or dangerous ordinance, to wit, a firearm, and at the time the defendant had been adjudicated a delinquent child for the commission of an offense that, if committed by an adult, would have been a felony offense of violence, to wit, attempted rape, in the Hamilton County Juvenile Court under case number 22/002266/01 on January 31st, 2023. And at the time the defendant had not been relieved from such disability under operation of law or legal process, cited weapons while under disability, a felony of the third degree, in violation of revised code section 2923.13A2 for the forfeiture specification. The grand jurors further find and specify that on or about October 28, 2025, George Hopper possessed a Taurus G3C 9mm and said property was used in the commission of counts 1, 2, and 3 hereof.
All right, thank you. Anything on those facts, counsel?
Nothing on those factors.
All right, Mr. Hopper, your prosecutor said you did,
Yes, ma'am.
is it true?
Yes, ma'am.
What is your plea to count one, having weapons all under disability and all in the third degree?
Yes.
That's corporate, that record reflects that the defendant, Mr. George Hopper, was present in court with his attorney, Mr. Neil Bachelor, and that Mr. Hopper was informed of all his constitutional rights and has made knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Hopper understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Mr. George Hopper guilty of charge with count one, having weapons of all disability, a felony of the third degree, in violation of revised code 2923.13, subsection A2. Counts 2 and 3 are dismissed at the state's request. Counsel, is there any reason why sentence should not be issued today?
Your Honor, we would ask the way PSI move forward since we today.
All right, I'll let you do PSI. All right, who's next on behalf of Mr. Hopper?
Thank you, Judge. In mitigation, Mr. Hopper, as he said, is 22. He is a high school graduate. He's also a young father. He has a 4-month-old son. At the beginning of this case, Your Honor, he worked for his family's construction company. It was something that he had been doing since he was a teenager. But part of his bond initially included EMU. So because EMU required more of a schedule, he ended up leaving the family business and going to get a job where he could actually show EMU's schedule. He ultimately came before this court asking to be removed from EMU, which the court did do. I will note that he complied with all of his bond requirements throughout the pendency of his case. One of the main reasons why he was asking to get off EMU was because he is a father, things can come up with his young son, so he wanted to be able to make make sure he's there to help this significant other. She is in the courtroom this morning as well, Judge. I will note that his disability is based on a juvenile adjudication. And I have clients who often are not aware that their juvenile adjudication puts them under a disability. Now, I understand ignorance of the law is not a defense, but I do not think Mr. Hopper was in a position where he was knowingly and actively violating the law. I would note that this firearm in this case was not reported stolen. We're not before you with any receiving stolen property charges. However, Judge, he does now understand this juvenile adjudication that prevents him from having firearms. Now that he is a father, he doesn't want anything to do with any firearms. Judge, I do think that Mr. Hopper would be a good candidate for probation. He did spend 2 days in the Justice Center before he was released on.
All right, thank you very much. Steve?
Your Honor, it's my understanding the state will be deferring to the court for sentencing. However, the state will accept the firearm be ordered forfeit.
All right, thank you very much. Mr. Hopper, is there anything you'd like to say before I pass sentence?
I just want to say, because it's a bad, like, really bad thing I did. And I don't hang out with them people no more. I don't associate with them people no more. I don't have nothing to do with them anymore, because all they did was drop my life downhill. And I have my son, and it's the best thing that ever happened to me. And I just think about it.
All right. So why did you have them? You were with the wrong crowd?
The wrong crowd was basically everything was happening. I was going down town. I was hanging out in there, and I knew everything else happening down there. I was just carrying for protection and trying to just follow other people, basically.
And what did you learn about it?
I learned to not follow the people that I used to follow in my past life, and to go and do what I need to do and get a job and make money for my son and make the man that my son wants me to be.
So, you know, there's a saying, and it's a saying, it's a cliche, but the saying goes something like, if you look at the 5 people around you, that will determine what your life is going to look like. You see what I'm saying? So it's the influence that people have. So the people that are closest to us, they have influence in our lives, negative or positive. And so it's very important as a young man, as a young father, that you choose wisely who you give access to, who you bring in close. Now, we all have people that we know that, you know, are going left, right? Those people are not people who bring close to you. Because the people who bring close to you, you're around all the time. They have impact on your life. And you just found out at a very young age. So I hope you learned your lesson though. The court has considered overriding purposes of the sentencing to revise code 2929.1, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I reasonably calculated the sentence to achieve the 2 overriding purposes of felony sentencing and to be commensurate with and not leading to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the recidivism factors and seriousness as set forth in revised code 2929.12. Accordingly, Mr. Hopper, I hereby sentence you to a term of community control probation, 2 years. You can breathe it down. You can breathe the words. Community control, intensive supervision, and the firearm will be forfeited, cost of fines will be remitted. Now, I'll tell you the good news and bad news. Good news is, if you do what you're supposed to do, keep a job, you stay out of trouble, I'll consider releasing you on probation early. The bad news is, if you do not, and pick up your charge, find yourself in violation of the law, I will not hesitate to sentence you to a term of 36 months in the Ohio Department of Corrections, which is 3 years. Do you understand? All right. Anything else, counsel?
Nothing else from the defense, Your Honor.
All right, Mr. Sawyer?
Nothing to say now.
All right, Mr. Butler, you right to appeal your conviction and sentence. If you do so, you must do so within 30 days. If you're not going to process the appeal, the attorney will be appointed to help you with the cost to you. You understand?
Yes, ma'am.
All right, I wish you well.
Take
You
it.
have to go to probation, but I can work. We're gonna send the paperwork ahead, you so you don't have to wait. All right, Mr. Diamond. I think you had Mr. Dorsey.
Yes, Your Honor.
This is, it is that. This is what we're doing.
Okay.
This is Matt State of Ohio, Mr. Keith Dorsey, case number B250653, Mr. Dorsey, present in the courtroom, with his attorney, Mr. Donovan, and Mr. Brandon Brown, from the state of Ohio. This matter is set for a jury trial. Counsel, you ready to try?
Here,
State?
this is on Dorsey.
Yes.
Judge, I believe I have a prosecuting witness here on Mr. Dorsey's case. The officer was present, but I do not believe that I have the actual person who owned the account. So say it's not.
Is this a business or is this a,
No, it's an individual.
individual? I mean, it's subpoenaed, are we subpoenaed?
Yes, the subpoena was left at the residence by the officer. Did not make personal contact, but I have not been able to contact that person since we got this case, Judge.
I see you've been several times.
Yes.
The officer, you have either.
No.
Okay,
You try.
all right. All right, Mr. Gunn?
Your guess for dismissal, we're obviously prepared to go forward. I also, my understanding in this case, I don't even know that there was actually money that the alleged victim was found. I believe the transaction was stopped by the credit card company.
All right. Well, the matter will be dismissed without prosecution. I will the officers present and the prosecuting witness. Mr. Dorsey, why are you late?
I thought I put it on my calendar, if it did. No, the matter showed up this morning, and we'll do it my hearing now for the interview this later this afternoon.
Oh, I see. All right, well, you know, I hope you never find yourself back in front of a judge or in a situation like this before, but everybody's not going to be grace here. You understand?
Yes, I understand.
All right, now it's dismissed.
Thank you. Yes, well, what's your good?
All right, this is Mr. Chairman Williams. It's the United States of Ohio, versus how are you now first name? Tyler.
Yes, sir.
Tyler Williams, case number B25071778 and B25035567. Mr. Williams is present in the courtroom, his attorney, Mr. Jeff Diamond, Mr. Brandon Brown, from the state of Ohio. These matters are on today for a jury trial and a probation violation. We'll handle the probation violation after we handle the first case. So, it's my understanding that the parties have reached an agreement on the hand plea documents. Counsel is saying final to proceed?
Yes, Your Honor.
All right, Mr. Williams, is that accurate?
Yes, sir.
Yes.
Yes, ma'am.
Okay.
Sorry.
Are you the Tyron Williams named in this indictment?
Yes, sir.
And Mr. Williams, can you tell me how old you are?
29, yes, sir.
And how far are you in school?
Some college.
All right, so you're writing English language.
Yes, sir.
Are you a U.S. citizen?
Yes.
Have you ever served in the military?
Yes, sir.
You have?
Yes.
Which branch?
The Marine Corps.
And, well, thank you for your service.
Thank you.
This is, are you better?
Yes, ma'am. Yes. Yes, ma'am.
Yes, Your Honor, I've been in contact with registry about, it doesn't appear that he can afford that for, but about coming to a resolution for him as far as, so we hope to propose that sentencing. So registry is involved in this case, Judge.
Okay, thank you. All right. Ms. Williams, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize your attorney, Mr. Diamond's signature here, but right above where it says defendant, is that your signature?
Yes, ma'am.
All right, thank you very much. And I noticed that the probation officer came in today.
Yes.
Name?
Robert Ellis.
That's right, Mr. Ellis. Are you your appreciative?
No, I'm not actually his assigned probation officer. He's a Keisha.
Oh, she is, okay, okay. But you're just covering today?
Yeah, I'm just filling in today.
Thank you very much, I appreciate that. Mr. Williams, this is an acknowledgement by you that you understand that you have a constitutional right to have a jury trial, which is set for today. But when you sign this form, you're indicating to the court, I understand my right, but I don't want to have a trial. I'm waiting to give it up to have a trial. Is that your understanding of what you're doing when you sign this form?
Yes, ma'am.
You signed this form after consulting with your attorney about your constitutional right to have a trial?
Yes, ma'am.
Do you have any questions about this form?
No, ma'am.
Do you have any questions about your constitutional right to have a trial?
No, ma'am.
I also have in my hand a 3-page document. And it's entitled, Entering Drawing Plea of Not Guilty, Entering a Plea of Guilty. And on the 3rd page of this document, there are signatures. I recognize, is this Sawyer's signature?
Yes, sir.
Okay, this is Sawyer's signature, there on the back of the state of Ohio. Mr. Diamond's signature there, I recognize. The correct here, sir, is that where you signed it?
Yes, ma'am.
All right, thank you very much. Mr. Brown, please put on the record the price expectation regarding this plea.
Yes, sir. Expectation is Mr. Williams plead guilty to count one as charged, breaking the point as a felon of the 5th degree, state and dismissing counts 2, 3, and 4.
All right, thank you very much. Mr. Diamond, is that accurate?
Good.
Mr. Williams, is that your understanding too?
Yes, ma'am.
All right. Mr. Williams, are you under the influence of any medications, alcohol, or drugs today?
I take anxiety medicine, Zoloft,
And is that for anxiety?
antidepressant too.
All right, thank you very much. And did you take it this morning or last night?
This morning.
All right, and does it help you to, with your mood stabilization?
Yes, ma'am.
All right. Do you now, or have you ever had to, manage any type of mental health difficulties other than what you just described?
Yes, ma'am. I've been diagnosed with depression, PTSD, and anxiety.
Okay, and has, any medical professional ever prescribed any medications to help you manage the, those conditions, PTSD, and, other than, Zoloft?
Yes, ma'am. I've been prescribed Visceral, Seroquel for sleep, and Visceral for anxiety at times,
Okay.
certain times.
All right, and have you been able to, continue that medication regimen while you've been in the justice center?
Yes, ma'am.
All right, thank you. Are you presently under any type of probation or community control supervision in this state or any other state other than the case to me?
No.
Probation to me?
No.
Okay. Has anyone forced, threatened, or coerced you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything at all other than the dismissal of counts 2, 3, and 4 if you enter a guilty plea to count 1?
No, ma'am.
Are you making this plea of your own free will?
Yes, ma'am.
Now, the state has indicated this is a 4-count indictment, but based on your attorney's negotiations on your behalf, with the state of Ohio, it's expected that you would enter a guilty plea to count 1, and the remaining counts be dismissed. Is that what you talked to Mr. Diamond about before this hearing today?
Yes, ma'am.
And did you have an opportunity, Mr. Williams, to review this 3-page plea form with your lawyer before today's hearing?
Yes, ma'am.
Do you understand what it says?
Yes, ma'am.
Any questions?
No.
Did Mr. Diamond answer all your questions about
Yes, ma'am.
it? Mr. Williams, do you believe that you have enough time to sufficiently consult with your attorney about your entire case before this hearing today?
Yes, ma'am.
And has Mr. Diamond answered all of your questions to your satisfaction?
Yes, ma'am.
Have you had an opportunity to either review and or discuss the evidence the state has against you?
Yes,
Mr. Prosecutor, please put it on the record whether or not the state has provided all discovery evidence, including any grade material evidence that you need to your knowledge of the defense.
Yes, Judge, the state is providing all known discovery.
All right, Mr. Diamond, you acknowledge the same?
Who do you know?
Mr. Williams, are you satisfied with your attorney, Mr. Diamond?
yes, ma'am. It's doing pretty good.
All right, thank you. Now, do you understand the charge on count one, breaking and entering a felony of the fifth degree?
Yes, ma'am.
You understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations of breaking and entering as charged.
Yes, ma'am.
And you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately.
Yes, ma'am.
Now, count one being a felony of the fifth degree, it's a low-level felony. Do you understand that you're facing up to 12 months in prison and up to a maximum fine of $2,500?
Yes, ma'am.
You understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years?
Yes, ma'am.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence?
Yes, ma'am.
Mr. Williams, are you on post-release control right now?
No, ma'am.
Well, do you understand that if you are on post-release control and you're convicted of a felony offense while on post-release control, in addition to being punished with a new felony offense, the sentencing board could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand?
Yes, ma'am.
All right, any questions?
No, ma'am. I won't do so.
Okay. Since this is a felony of the fifth degree, a low-level felony, community control and probation is a possibility. Do you understand I place you on probation for up to 5 years instead of sending you to prison?
Yes, ma'am.
Do you understand that if you are placed in a community control sentence, you would have to abide by all probationary conditions as established by this court?
Yes, ma'am.
And if I place you on community control and you violate the conditions, you're gonna be brought back before me for a more restricted sanction, which could include a whole host of penalties, but the most severe penalty, I'm sorry, let me say this. If I place you on community control and you violate the conditions of community control, you're gonna be brought back before me for a more restricted sanction. Do you understand that?
Yes, ma'am.
And that restricted sanction could include a whole host of penalties, but the most severe penalty could be the imposition of prison time up to the 12 months I previously discussed with you. Do you understand?
Yes, ma'am.
Any questions?
No, ma'am.
Also, if I impose court costs and we fail to pay those court costs as related, I can just go into community service that pay court costs. Understand?
Yes, ma'am.
Any questions?
That's the point.
Alright. So what I usually tell people, and if you already know this, I'm still remind you, that when I place someone on community control, I fully accept they're going to be complying. But there are some ways that people are not complying. One way is they get a new charge, they get a new conviction. That's violation of community control, supervision. The other is that they just don't comply with all the conditions. And then the third way is they leave the state without permission of the court or probation. Do you understand?
Yes, ma'am.
When you plead guilty, you give up some very important constitutional rights that I have to make sure that you understand. Do you understand? That you have a constitutional right to have a trial either to the court or to a jury of 12 persons.
Yes, ma'am.
Do you understand you have a constitutional right to confront witnesses here in court and have them cross-examined by a lawyer?
Yes, ma'am.
Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you?
Yes, ma'am.
Do you understand that at a trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
And finally, do you understand that at a trial, you cannot be forced to testify against yourself?
I didn't know that, but yeah, I just.
Okay. thank you. Do you have any questions about your constitutional rights?
No,
Do you understand these rights that I signed?
yes, ma'am.
Do you understand that if you plead guilty, you are waiving all of these important constitutional rights in this case?
Yes, ma'am.
Knowing everything the court has discussed with you, do you still wish to enter a guilty plea as charged with count one, breaking and entering a felony of fifth degree?
Yes, ma'am.
Counsel, is there any further request of a plea on this case?
No.
All right, and your statement facts.
Terry Williams, owner of December 25th, 2025, in Ames County, State of Ohio, by force, stealth, or deception, trespass in an unoccupied structure belonging to another with purpose to commit any theft offense as defined in section 2913.01 of the revised code or any felony therein. Judge, he was seen breaking into Family Dollar and still not mentioned.
All right, which candidate?
This is located on East Seymour, Judge.
I'm sorry.
East Seymour.
Oh, that's close enough. Okay. All right, anything on that, counsel?
No.
All right, Mr. Williams, here, prosecutor, did,
Yes, ma'am.
is it true?
Yes, ma'am.
What is your plea count on breaking and entering, felony of fifth degree?
No, that's ma'am. I'm just guilty. Well, guilty, I guess, I'm sorry.
Okay,
I
no,
thought it's the same thing.
okay, what do you want to plead?
Guilty.
All right. The court, the record that Mr. Tyron Williams, president court with his attorney, Mr. Dunn, and Mr. Williams was afforded all his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Williams understands the nature of the charge, the effective plea, as well as the maximum penalties that can be imposed. Finding it to be voluntary, the court accepts his guilty plea and finds Mr. Tyron Williams guilty of charge of count one, breaking and entering a felony of the fifth degree in violation of Revised Code 2911.13 subsection A. Counts 2, 3, and 4 are dismissed at the state's request. Counsel, is there any reason why sentence should not be entered on this case?
Yes, Your Honor, we would be requesting that PSI in this case. We're also working with the registry to come up with some stuff that we would like to present prior to sentencing, Judge.
Okay, so we will get a sentencing date. In the meantime, let's handle the probation violation. Counsel, would you like to have a, probable cause hearing on case B 2503567?
No.
All right, probable cause to waive your statement facts.
Karen Williams violated rules 2, 5, and 10 of community control. Specifically, he picked up new charges on December 25th, 2025. The defendant has failed to provide any evidence of verifiable employment or enrollment in educational programming. The defendant has also not made any payments for probation fees or restitution.
All right, anything on facts, counsel?
No, Judge.
Mr. Williams, you give the prosecutor said you did.
Yes, ma'am.
All right, to violate your community control.
Yes, ma'am.
All right, is it true?
Yes, ma'am.
You had paid toward your restitution and you just actually couldn't done.
Yes, ma'am. I haven't had much time to make payments. I've been working on getting a appointment. I sent all my applications to my progressive officer. She has the list, and I just didn't have enough time for a company change.
All right, thank you very much. What's your plea?
Guilty.
All right. Guilty plea is accepted and entered and finding guilty on the probation violation. Ms. Howard, can we get a date so we can continue the sentencing for both matters? Tuesday, May 19th. Tuesday, May 19th.
That works for me.
Tuesday, May 19th, it'll be at 9:30, Mr. John.
Thank you, Judge.
Both of these matters will be on. Is there anything else you want to do before we adjourn these matters?
Yes, Your Honor, the state to state, I would be asking to the court be willing to address bond. Since he has entered the plea, he's been locked up for
rather a sizable amount of time. He's got good support. His wife's here reporting with him today.
Who's here?
His wife, she's been at the rest of his court case. She's been in contact with me, obviously concerned about his well-being. She said that if we would be asking the court to consider putting him on E&D lockdown, she said that he would be able to stay at her residence with her. She would obviously make sure that he does what he needs to do and shows up for the sentencing day judge. Given that these are not violent charges, he has taken accountability. Again, he's been locked up, I believe, since December 25th of last year. I would be asking the court to consider modifying the judge. He's got a parole restore with a free, only 2 days to appear. That's how it is.
All right, Steve.
Judge, I was for, prosecuting witness, family Donald was here. The only thing they'll be asking for is sentencing, is a stay away, I believe there should be a stay away already in place regarding the board's bond on this, so we'll ultimately defer as far as any modification.
What do you still?
Judge, it was several miscellaneous items, I think looking at the report, I'd have to look and see.
What did you say, Mr. Williams?
I believe it's batteries.
That is light.
That's right. This is something that I was getting high. I needed something to help me get wide, pretty much.
And you can be honest about that.
Yes, ma'am.
Mr. Ellis, any recommendation at this time?
Any recommendation?
Any recommendation on trust?
No, ma'am.
It's been on the order 9 days on the Brewer case, Dawn, that they, I did the recommendation, there used to be some sort of River City. All right, I'm gonna, ma'am, you were willing to, having that you all saw this, you're all together? Yes, ma'am. On E&D? Yes, ma'am. All right, I'm gonna do the OR plus E&D. I'll bring it out to work, that's it.
Say that again, sir.
I'll allow you out to look for work,
Yes,
and that's it, you understand?
yes, ma'am.
The EMD is going to give you certain hours that you can look for work, and those are the only hours you can be out.
Yes,
Are you
ma'am.
clear?
That's not, I do have a question. I have 2 children. If it's not too much, he's in baseball right now. And baseball games are Saturday mornings. That I might just ask, but just go to baseball game. Be there for my son. Saturdays. If it's not too much.
Well, I'm gonna tell you that's very admirable, and that's good. But you can't be that skilled, and then I'm gonna be there for my son, like those two don't go together.
It does not just, I don't think I'm doing anything else to be away from my children and violate my probation.
All right, you can do, work hours. Or hours for employment, and what time they from?
They're gonna be, I will have a schedule wirelessly.
They're usually in the morning,
Yes, ma'am.
that's what time it is.
Like 10, they're probably 2 hours long. Sometimes they might be like 11 or 12, it just depends on.
No, he's not gonna get that kind of time. He will do 9 to 12 on Saturdays. So, it's gonna be something on this, you understand?
Yes, ma'am.
Okay. So, all right, OR, EMD, work hours of work, and Saturday is 9 to 12.
Thank
And we'll see you back here May 19th with no charges.
Yes, ma'am.
All right?
I'll be here.
All right.
Thank you.
Thank you, Judge.
Is that on both cases?
Have a good day.
Thank you. Thank you, Dallas, covering. All right, you ready for the term?
Yeah.
You do.
Yes.
Okay, you guys want to talk to me about it? That's what she schools them.
Where I am right now is I met with the prosecutor on this case. She is 8. She's pretty reluctant to speak in jail. I would say there's an argument to make. She'd be competent, but she'd be pretty saying it's subject to cross-examination. Additionally, something we talked about last time, so the case, I don't have a recording person. So I don't have anything to substitute for her testimony. She's not going to stand with her grandparents. I believe I don't know if they have to really involved. She's currently staying with her. If there is an ongoing custody, I don't know if private children for JS is going in custody. They, I don't know if they are pushing out. In addition to this, this last year, she's the following that they were talking about. She's been having some exclusive outbursts as well, since just issues that they need to be discussed. Working that, obviously, just this new class of she has other from the minutes who are helping right now. I think that she might be ready. I think she's speaking to the judge. Just the thought process of saying, but every child is based on the nature of the leadership and the keys in it. There's some questions about this. Speaking of Ireland, she really doesn't overcome the talk about. That's also the next word, is talk about how many children they don't have. They're saying they don't have children, trying to not do that. All of the statements that we teach you, not totally good, she kind of talks about it happening. I think it was it says something like this because the serious potential for substantial risk of serious physical harm is going to be issue of trauma. The nature themselves are not serious, they were raised on teaching them strapped. They're not necessarily scars. Husband, she had to say basically, which obviously doesn't have to be large, but that can be serious in the sense of nature of it. But it's really between those two things, and whether or not she would go unjustified attempt to have a justified case. So that's kind of what I heard. I know I talked to the grandfather, I talked to the about this, the book, the one that honestly the book is about custody. But this court is going to be having how many things that's going to match together and just say, you feel like this is meant to be looking at, should be testing. That's how I read that way too, just, I'm not really, I'm not really
Can you choose a 30, April 30?
What'd you say? I said, I think I said, I'm going to say, anything else. Because it goes back on the edge.
All right, you ready? This is a matter of the state of Ohio versus Alidra Urbans. Case number B250442. This person is present in courtroom with her attorney, Ms. Leila Bachelor, and Ms. Brandon Rock of the state of Ohio. This matter is set today for jury trial. And it's my understanding the price of reaching agreement. Is that accurate, Ms. Bachelor?
That is correct, Judge.
All right. Mr. Brown, is that?
Yes, Judge.
All right. Are you the Alidra Urbans name, Mrs. Bachelor?
Yes,
Ms. Urbans, how old are you?
I'm 30 years old.
How far have you gone to school?
I have my bachelor's degree.
So you're able to read and write English language well?
Yes,
Are you a US citizen?
yes,
Have you ever served in the military?
no,
Ms. Urbans, I have in my hand a single page document It's entitled Waiver of Trial by Jury, and the bottom there is signature. I recognize Ms. Bachelor's signature here, but right above, is that your signature?
Yes.
This is an acknowledgement by you that you understand you the constitutional rights of trial, the jury trial, which is set for today. But when you sign this form, you're indicating to the court, I understand my right, and I don't want to have a trial. I'm waiving or giving up my right to have a trial. Is that your understanding of what you're doing when you sign this form?
Yes.
You sign this form after consulting with Ms. Bachelor about your constitutional rights to have a trial?
Yes.
Do you have any questions about this form?
No.
Do you have any questions about your constitutional right to have a trial?
No.
I also have in my hand a two-page document. It's entitled, Entry of Drawn Plea of Not Guilty, Entry of Plea of Guilty, Reduction to Misdemeanor. On the second page, there are signatures. I recognize Mr. Brown's signature here, prosecutor, Ms. Bachelor's signature right above, and then right here. Is this your signature or is that the signature of the defendant?
Yes.
All right. Mr. Prosecutor, please put on record the party's expectation regarding this plea.
Judge, expectations, Ms. Irvin will plead guilty to count one as reduced and amended from child endangering as a felony of the third degree to child endangering as a misdemeanor of the first degree, stated in dismissing counts 2 and 3.
All right, and that is with the consent of the victim and bearer.
Yes, Judge, I've spoken with the grandparents who are the current care providers, the prosecuting witness, as well as the officers on this case.
All right, thank you very much. Ms. Bachelor, is that accurate?
That is correct, Judge.
Is that your understanding too, Ms. Perkins?
Yes.
Before I go any further, there were 7 pending motions in limine. Ms. Bachelor, do you want to withdraw those at this time?
Yes, Judge, I will withdraw all pre-trial motions.
Okay. So the only motion to withdraw the pending pre-trial motions, all of them, is granted and they're withdrawn. All right. Ms. Perkins, are you under the influence of any medications, alcohol, or drugs today?
No.
Do you now, have you ever had to manage any type of mental health difficulties?
Yes.
Can you tell me a little bit about that?
About my mental health?
Yes.
Yes, I'm currently diagnosed with generalized anxiety, PTSD, and bipolar 2 disorder.
And have you ever been prescribed by medical professionals any medications to help you manage those conditions?
Yes.
Are you currently compliant with that medication regimen?
Yes.
All right. Are you presently under any type of probation or community control supervision in this state or any other state?
No.
Has anyone forced, threatened, or coerced you in any manner into entering into this plea of guilty today?
No.
Has anyone promised you anything at all? If you enter into this plea of guilty today, other than the dismissal of counts 2 and 3?
No.
Are you making this plea of your own free will?
Yes.
Now, the state, and it's my understanding, this is the state said, but it's my understanding that this is an indictment with 3 counts. But based on your lawyer's negotiations on behalf of you with the state of Ohio, the state is asking that I amend and reduce the count 1, which is endangering children, felony of 3rd degree, down to endangering children, misdemeanor of 1st degree. Is that what you talked to Ms. Bachelor about today?
Yes.
And did you talk to her about that before signing this plea agreement?
Yes.
All right. Did you have an opportunity to go over this 2-page plea agreement with her before this hearing?
No. You mean my?
This is the plea form.
Yes. Yes. Yes, I understand. I'm
All
sorry.
right. Did you understand what it says?
Yes.
Do you have any questions about it?
No.
Is that your answer to the questions about it?
Yes, you did.
Ms. Irving, do you believe that, you had enough time to sufficiently consult with your attorney about your entire case for this hearing today?
Yes.
And has Ms. Thatcher answered all of your questions to your satisfaction?
Yes.
Have you had an opportunity to either review and or discuss the evidence the state has against you with Ms. Thatcher before today's hearing?
Yes.
All right. Mr. Prosecutor, please tell the record whether or not the state has provided all discovery evidence, including any grading material evidence, if any to your knowledge of this.
Yes, Judge, the state's provided all my discovery in this case.
Ms. Thatcher, not please.
Yes.
Ms. Perkins, are you satisfied with your attorney, Ms. Thatcher?
Yes.
Now, do you understand this charge in count one as being, well, it's being reduced, not amended, to endangering children and misdemeanor of first degree?
Yes.
And do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations of endangering children, misdemeanor of first degree?
Yes.
And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes.
Now, this being reduced to a misdemeanor of first degree, do you understand that you're facing up to 180 days in jail
Yes.
and up to a maximum fine of $1,000?
Yes.
Do you understand that also, because this is a misdemeanor offense, a misdemeanor of first degree, that community control probation is a possibility?
Yes.
And do you understand that as such, I can place you on probation for up to 5 years instead of sending you to jail?
Yes.
You understand that if you are facing a community control sentence or a probationary sentence or a probation sentence, you would have to comply with all probationary conditions as established by the court.
Yes.
And if I place you on community control for probation and you violate the conditions, then you're going to be brought back to warning or more restrictive sanctions, which could include a whole host of penalties. So the most severe penalty could be the imposition of jail time up to the 108 days that previously discussed. Do you understand?
Yes.
You have any questions?
No.
Also, when I post court costs and you get able to pay those court costs, I could award you to community service instead of paying court costs. You understand?
Yes.
I'm sorry, that's talking so much. Ms. Perkins, if I were placed on community control or probation, I would fully expect that you would be compliant. But can I tell you a few ways that people are not compliant? The first is that they get to be charged if they get to the offense. That's immediate and direct violation of community control. Do you understand?
Yes.
In addition, there's another big way that people violate, and that is they don't comply with all conditions of probation. So they make 5 conditions, they do 4, maybe 8 conditions, they do 7.5. That's immediate and direct violation of community control. Do you understand?
Yes.
And then the last one, big way people violate that's not as commonly known, and that is to leave the state without permission of probation or the court. You understand that?
Yes.
And the reason why that's important in where we live is because we're bordering Northern Kentucky. And so to leave the state without permission, violation. Okay?
Yes.
Any questions about that?
No.
Any questions about anything we discussed here today?
No, Your Honor.
When you plead guilty, you give us very important constitutional rights. I have to make sure that you understand. Do you understand that you have a constitutional right to have a trial, which is set for today, either to the court or to a jury of 12 persons?
Yes.
You understand you have a constitutional right to confront witnesses here in open court and have a cross-examined by your lawyer?
Yes.
Do you understand you have a constitutional right to have witnesses subpoenaed to come to court and testify for you?
Yes.
Do you understand that a trial is the obligation of the state of Ohio to prove your guilt beyond reasonable doubt?
Yes.
And finally, do you understand that at a trial you cannot be forced to testify against yourself?
Yes.
Do you understand that these rights are disclaimer?
Yes.
Do you have any questions about your constitutional rights?
No.
Do you have any questions about anything we discussed here today?
No.
Knowing everything the court has discussed with you today, Ms. Perkins, do you still wish to enter into plea to reduce charge of endangering children and misdemeanor in the first degree?
Yes.
Counsel, is there anything further to accept the plea?
Nothing else from the bench, Judge.
Okay, Mayor, state the facts.
Lee Perkins on or about August 15th, 2025 in Hamilton County, state of Ohio, while being the parent, guardian, custodian, person having custody or control, or person in local parentis of a child under the age of 18, did create substantial risk to the health and or safety of IJ, who was a child under the age of 18 at the time. Judge, the prosecuting witness in this case, she ended up running away from her mother, and officers found her. As a result of the mother's discipline, she had multiple markings that appeared to be from a strap on her arms, legs, and her face as well. Ultimately, she was taken to the hospital from this.
All right. Counsel, anything on those facts?
Nothing on those facts, Judge.
Ms. Perkins, your prosecution did,
Yes.
is it true?
Yes.
Go to your plea to count one, endangering children and misdemeanor in the first degree.
Guilty.
Let the record reflect that Ms. Alethea Perkins was present in court with her attorney, Ms. Jamila Batchelor, and that Ms. Perkins was informed of all her constitutional rights and stated knowing, intelligent, and voluntary waiver of those rights. The court finds that Ms. Perkins understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Alethea Perkins guilty as to count one, endangering children, a misdemeanor of the first degree in violation of Revised Code 2919.22. Counts 2 and 3 are dismissed at the state's request. Counsel, very busy why sentence you have to today?
Your Honor, we would ask for PSI in this matter.
All right, and the state has for the tax statement?
Yes, Judge.
All right. I will order that and I will continue this to Ms. Howard. April 30th at 9:30 for sentencing. Is that the date work for everybody?
That works for us, Judge.
All right. April 30th, 9:30. In person. And we will continue this then. Now, Ms. Perkins, what we need to do is I'm going to, decide what we're doing now. Send over paperwork to the probation department because we need to interview you. So I know more about you than what you did, other than what you did. And I will get a written report of your background and all that. I will share it with your lawyer and the prosecutor, and we'll be prepared for sentencing on April 30th at 9:30. We'll send the paperwork over right now so that we won't have to wait to get over there. And is there anything else, counsel?
Nothing from the first.
All right.
Nothing, Judge.
All right, there is a stairway that will stay in place, you can stay away from, the victim in this case. All right, thank you, your turn. Thank you very much. Thank you. Appreciate you. Hey, Laura, should we tell, the jury commissioner, the jury? Okay, and, Ms. Baxter, do you have the jury questionnaires, kind of goes back? Thank you. And then Laura, this goes back to Mr. Brown as well. Thank you. Did you already alert the jury commissioner this time?
Yes, ma'am.
Okay. Thank you.
Yes, that's one second.
Are you excited, Ms. Hunter?
Yes, excited, all
Yeah, well, it's okay. You'll be fine. You'll be nervous for about 3 weeks. And then, and then you'll get nervous when you have to do something new.
Yes, it's definitely,
And every time you gotta do something new, you'll get nervous. But, you'll be fine. You'll be great. Yes, we are done recording. Thank you, Mr. Brown. I think we continued some other days, we gotta get those to Ms. Howard.
Okay.
Get those before we leave, because I haven't gotten either. I think I continued, Mr.
7 runs in 3 innings. The Reds did make a bit of a comeback, but not enough to overcome the deep hole they dug early. Final score.
Because, Mr. Neff, he came late. I'm trying to get this case ready for trial.
Mr. Black, 427 at 9:30.
27 at 9:30.
And then Cecil Johnson.
Bye.
See you next time. I said Cecil Johnson for a plea on 4.